Justice Breyer has our opinion this morning in Case 15-274, Whole Women's Health versus Hellerstedt.
We here consider the constitutionality of two statutory provisions of Texas law, both of which regulate facilities where abortions are performed. The first provision concerns hospital admitting privileges. Before that provision was enacted, Texas law required an abortion facility to maintain a written protocol for managing, among other things, the transfer of patients requiring emergency care to a hospital. The law before us adds a requirement that a doctor performing or inducing an abortion have active admitting privileges at a hospital within 30 miles of the facility where the abortion is performed. The second provision says that, quote, the minimum standards for an abortion facility must be equivalent to the minimum standards for ambulatory surgical centers. We have to decide whether these two provisions are consistent with the federal Constitution as interpreted in our 1992 case, Planned Parenthood versus Casey. We find that they are not consistent with the constitutional standards set forth in Casey, and we hold both provisions unconstitutional. The Federal District Court, after a trial, found the two provisions were unconstitutional. They constituted an undue burden on a woman's right to choose. The Court of Appeals for the Fifth Circuit reversed. We, in turn, agree with the District Court, and we reverse the Court of Appeals. The Fifth Circuit upheld the two provisions in question for several different reasons, independent reasons often, and we explain at length, in our opinion, why we reject each of those reasons. I shall here summarize our basic reasoning. First, the Court of Appeals pointed out that some of the doctors who brought this lawsuit had been part of an earlier case in which they also challenged the constitutionality of the admitting privileges requirement. They lost the case. For that reason, the Court of Appeals held this lawsuit is barred by principles of res judicata, which is a legal doctrine that says, in essence, you only get one bite at the same apple. The question, however, is whether what we have here really is the same apple. Seeking the answer to that question in well-established legal principles, we conclude that it is not the same apple. The restatement of judgments points out that, quote, material operative facts occurring after the decision in a first action may provide a basis for a second action, even if the second action in other respects resembles the first. Suppose a group of prisoners claim that a state is violating the Constitution by making them drink unhealthy water, and they lose the claim, not enough evidence. But then suppose quite a few of them die of water contamination. Because of that new critically important evidence, they could bring a second action, similarly attacking the constitutionality of the state's actions, even if the second action was in other respects, like the first. The plaintiffs here brought their first case before the Texas law took effect. They brought this second case after it had actually taken effect and clinics had actually closed. So we think it's rather like the prisoner hypothetical. Second, the circuit court thought that the physicians should have brought their challenge to the surgical center requirement earlier. At the time they first challenged the admitting privileges requirement, the court concluded that that same doctrine about the apples, res judicata, means that because they could have brought the surgical center challenge then, they can't bring it now. In our view, however, res judicata does not require those who wish to challenge one part of a complicated regulatory law, say like the long law that regulates securities or drugs. It doesn't require them to challenge every part of that complex statute at the same time. The provisions that are challenged here are distinct regulatory requirements, and so the doctors are free to challenge the surgical center requirement here in this new action as they have done so. Third, Turning to the constitutional merits, we think the Fifth Circuit applied the wrong legal standard. That court said, quote, medical uncertainty underlying a statute is for resolution by legislators, not by courts. In Casey, however, the plurality wrote in its governing opinion that, quote, a statute which, while furthering a valid state interest, has the effect of placing a substantial obstacle in the path of a woman's choice, cannot be considered a permissible means of serving those legitimate ends, and it added unnecessary health regulations that have the purpose or effect of presenting a substantial obstacle to a woman seeking an abortion imposes an undue burden on that right. And in Gonzalez v. Carhart, we pointed out the court retains a, quote, independent constitutional duty to review factual findings where constitutional rights are at stake. We follow, as we must, Casey and Gonzalez here, and in doing so, we decide whether there is undue burden, looking to the existence or non-existence of medical benefits, as well as the burden the law imposes on a woman's access to abortion facilities. Fourth, we find adequate legal support in the record for the district court's conclusion that the admitting privileges requirement imposes an undue burden on a woman's right to have an abortion. The purpose of the requirement is to help ensure that women have easy access to a hospital should complications arise during an abortion procedure. But the district court described abortion procedures in Texas as already extremely safe, and it found that when compared with prior law, which you will remember already insisted upon a written protocol for transferring patients to a hospital in case of need. In comparison to prior law, the court said the admitting privileges requirement brought about no health benefits. The record backs this finding up with peer-reviewed studies, with detailed expert testimony, which we describe in our opinion. Indeed, when directly asked at oral argument whether Texas knew of one single instance in which the new requirement would have helped even one woman obtain better treatment, Texas responded that there was no evidence of such a case in the record. At the same time, the district court found that as of and soon after the time Texas began to enforce the new requirement, the number of facilities providing abortions in Texas dropped from about 40 to about 20. The record contains sufficient evidence of a causal connection between the new law and those closures. The closures mean fewer doctors, longer waiting times, increased crowding, and significantly greater travel distances, all of which, when taken together, burden a woman's right to choose. In sum, the admitting privileges requirement places a burden upon a woman's right, which, given the lack of health benefit, is undue. Fifth, the second provision of Texas law requires an abortion facility to meet Texas minimum standards for ambulatory surgical centers. We conclude that this provision, too, imposes an undue burden upon a woman's right to choose. Before enactment of the provision, abortion facilities were required to meet, and they still are required to meet, a host of health and safety standards involving, for example, staffing, physical facilities, infection control, medical procedures, clinical procedures, patient rights, and others. The surgical center provision requires, in addition, that a facility maintain, for example, personnel trained in cardiac life support, an operating room with a clear floor area of at least 240 square feet, a post-operative patient holding room, a post-operative recovery suite, a one-way traffic pattern, and they must meet special surgically related standards concerning ventilation, air conditioning, piping, plumbing, and others. The district court found that requiring abortion facilities to meet these requirements will not provide women with better care or more frequent positive outcomes, and the record adequately supports this conclusion. It shows, for example, that abortions in Texas prior to the new law were safe, with a total of 5 deaths occurring over 10 years, or about 1 per 120,000 to 140,000 abortion procedures. By way of comparison, childbirth, ordinary childbirth, is 14 times more likely to cause death. Colonoscopy has a mortality rate 10 times as high, and liposuction has a mortality rate 28 times as high, but Texas allows these latter procedures to take place at home or in a doctor's office. The record further supports the district court's conclusion that many of the surgical center requirements, such as standards designed to maintain sterile operating facilities, have nothing to do with medical abortions, where complications, should they arise, normally arise after the patient has left the facility. At the same time, enforcement of the surgical center requirements will place a substantial obstacle in the path of a woman seeking an abortion. The cost of compliance is high. To the court, where the court found it would reduce the number of abortion-providing facilities in Texas. Remember, it started at 40 to 7 or 8. The district court wrote that the proposition that these 7 or 8 providers could meet the demand of the entire state stretches credulity. The Court of Appeals said that that was clearly erroneous, but the finding rested upon the uncontested statement of an expert witness that the number of abortions the 7 or 8 clinics would have to provide would have to rise from 14,000 annually to 60 or 70,000. That's an increase by a factor of 5. And we think it's adequately supported, that conclusion, in the record. Suppose someone told you that a certain grocery store now serves 200 customers a week. A certain apartment building now provides apartments for 200 families. A certain train station now welcomes 200 trains per day. Well, it is conceivable that the store or the apartment building or the train station could just as easily provide for 5 times as many for 1,000 customers, families, or trains at no significant additional cost, crowding, or delay. But most of us would find this possibility highly improbable. In this case, Texas, looking outside the record, pointed to one new clinic that is able to serve 9,000 women annually. But were we to look outside the record, which we normally would not do, we would also have to note the construction of that clinic, the largest in the nation, seems to have cost $26 million, a fact that militates against, not in favor, of the ability of the 7 or 8 clinics to serve a large fraction of Texas women seeking an abortion. The upshot is that we find adequate legal support for the district court's finding that the surgical center requirement, like the admitting privileges requirement, provides few, if any, health benefits for women, poses a substantial obstacle to women seeking abortions, and constitutes an undue burden on a woman's constitutional right to do so. Sixth, finally, Texas argued here that in any event, we should not hold the 2 provisions of Texas law unconstitutional on their face, i.e. across the board, because of the statute's severability clause. Rather, the court should proceed clinic by clinic, examining each application of the provisions to see whether they impose an undue burden as applied in each particular case. In our view, however, the severability clause does not compel us to proceed clinic by clinic. We have determined that the provisions are facially unconstitutional based on the undue burden they impose on the large fraction of women they affect. Having reached that conclusion, proceeding application by application would impose enormous costs, both on courts and on litigants. It would also allow legislatures to insulate statutes from facial review. We consequently reject that approach. We elaborate further upon these and other matters in our opinion. For the reasons stated, and those contained in our opinion, we hold that the 2 provisions of Texas law, the admitting privileges requirement and the surgical center requirement, are unconstitutional, and we reverse the Fifth Circuit's determination to the contrary. Justice Ginsburg has filed a concurring opinion. Justice Thomas has filed a dissenting opinion, and Justice Alito has also filed a dissenting opinion, which the Chief Justice and Justice Thomas join.
We are supposed to be a neutral court of law, and that means that we have an obligation to apply the same legal rules regardless of parties and regardless of the nature of the case. Over the years, members of this Court have expressed strong and conflicting views about the constitutionality of laws regulating abortion. But when it comes to ordinary legal rules that apply in all cases, there is no justification for treating abortion cases differently from other cases. But with respect to that is what the Court has done in this case. The Court of Appeals held that the parties that brought this case were barred from doing so by the doctrine of res judicata, and the Court was correct. Now, that holding did not mean that these provisions of the Texas abortion statute would escape constitutional review. It meant only that these petitioners, these parties, could not bring another case challenging those provisions in the same way they challenged them in the first case. Other parties could challenge those provisions. Women seeking abortions in Texas could challenge the provisions. Other clinics could challenge the provisions. Other doctors could challenge the provisions, but not these petitioners. Res judicata, or to use the more modern terminology, claim preclusion, is a dry legal doctrine, and I am not going to go into a lot of details this morning. But I do want to say a couple of things. First, although the doctrine is dry and technical, it is important. In simple terms, it means this. If a party brings a claim in court, has a fair opportunity to make its case, and loses, and the judgment becomes final, the party cannot file another case raising the same claim. If we did not have this rule, litigation would never end. You know the old saying, if at first you don't succeed, try again. Well, that would be the rule, and that's the rule that the Court basically adopts in this case. If at first you don't succeed, sue again. The petitioners in this case filed an earlier case in which they targeted a provision of the Texas law requiring a doctor who performs abortions to have admitting privileges at a nearby hospital. They brought what is known as a facial claim, and what that means is that they claimed that the law is unconstitutional across the board. Petitioners had a fair chance to litigate that claim. They won in the district court, but they lost on appeal in the Fifth Circuit. They could have asked this Court to review the Fifth Circuit's decision. They decided not to do that, and the judgment against them became final. Then they went back and they filed a second lawsuit, but they did not try to relitigate their facial claim. If they had done that, they would have been subject to sanctions for abusive litigation. Instead, they raised a different claim, namely that the admitting privileges requirement is unconstitutional as applied in some parts of the state. The district court then did what petitioners had not dared to do. It revived the facial claim on which it had previously been reversed, and it again entered judgment for the petitioners, declaring that the requirement is unconstitutional across the board. This was obviously wrong, and the Fifth Circuit so held, but the Court now reverses. On what basis? The Court says that circumstances changed between the time of the first and the second cases. What this really means is simply that the Court thinks that petitioners had better evidence at the time of the second case than they did at the time of the first. This is contrary to a cardinal rule of res judicata. A party that loses the first time does not get a second chance just because that party has better evidence. If that were the rule, litigation would never end. A final judgment would not finally resolve the dispute, as it is supposed to do. Instead, it would just signal to the losing party to start looking for more and better evidence and then sue again. Now, Justice Breyer said that the Court's holding on res judicata in this case is supported by established legal principles. I invite you to read the Court's opinion and search for those established legal principles. You will not find any. The doctrine of res judicata predates the founding of this country. That's why it's in Latin. The Court does not cite a single decision of this Court that supports its decision. It does not cite a single lower court decision that supports this decision. The established legal authority boils down to a comment in the second restatement of judgment. Now, the Court ignores the fact that if you look at the actual rules in the second restatement of judgment, you come to the conclusion that the Court of Appeals was right. But the Court picks out a comment to one provision in this scholarly work and distorts the meaning of that, and that is the basis for its holding with respect to res judicata of the admitting privileges claim. Now, I'll say just a word about the other claim, the ambulatory surgical centers claim. This is not a case in which the two provisions just happen to be two provisions of a lengthy code like two provisions of the Internal Revenue Code. These are two very closely related provisions that are attacked by the petitioners as a package. Their claim is that these two provisions together cause the closure of clinics. They have made no effort to separate the effects of the two provisions. They describe them as delivering a 1-2 punch. Well, if the parties in lower courts apply the Court's res judicata holding here, in other cases, the law will be revolutionized. But perhaps they will recognize that this is an abortion case, and therefore the ordinary rules do not apply. I will not say more about res judicata, but I will add a few words about another holding that shows with unmistakable clarity that the Court refuses to apply neutral legal rules. The Texas statute contains what is known as a severability provision, and the issue of severability comes up when we hold that part of a law with numerous provisions is unconstitutional. What happens in that case to the parts that are valid? What matters is the intent of the legislative body that enacted the law. If the legislature thought that all the provisions are so bound up with each other that if one goes, the rest can't function as they should, then the entire law is out. But if the legislature thinks that the unconstitutional provision or provisions can be severed from the rest of the law, there is no ground for throwing out the valid provisions. The Texas law here involved in this case contains the strongest severability provision that this Court has ever seen. It is hard to imagine how a stronger one could possibly be drafted. It says that every single word in the statute and every single application of the statute is severable. The legislature made it perfectly clear that if any part of the law was found unconstitutional, it wanted to save as much of the rest as possible. The Court totally disregards the severability provision in this law. The Texas statute says that abortion clinics have to comply with all the regulations that govern ambulatory circular centers, ambulatory surgical centers. These regulations are voluminous. This is a printout of them. The Court holds that every single one of these regulations must go. Now, this morning, Justice Breyer cited 3 or 4 that supposedly impose a great financial burden on abortion clinics, and that may or may not be the case. But the Court's holding is not limited to those few provisions. Every single provision is held to be unconstitutional. Many of these are innocuous. Here are some examples. Patients must be treated with respect, consideration, and dignity. Is that unduly burdensome? Is that unreasonable? Nevertheless, it's gone. Patients must not be given misleading advertising regarding the competence and or the capabilities of the organization. That's gone. Centers must maintain fire alarm and emergency communication systems. That's gone. They must eliminate hazards that might lead to slipping, falling, electrical shocks, burns, poisoning, or other trauma. Gone. Why? There's verbiage in the Court's opinion, but it comes down to this, and this is what you just heard. It would just be too much work to go through all these regulations and figure out which are okay and which are not. So they all have to go. This is an abuse of our authority. We have no authority to strike down perfectly valid provisions of state law. And the work that should have been done is not work that this Court needs to do, going through all of these regulations one by one. It's work that the petitioners should have done in the district court and that the district court should have done. It should have identified the provisions that supposedly impose the undue burden and the rest should have been allowed to stand. Because the majority in this case has not done what a court of law must do, apply the law in a neutral manner regardless of the parties or the nature of the case, I respectfully dissent.